Thank you very much for attending today's Law with Lunch with myself. I'm Gemma Lieberman, and sharing the talk with me today is my trusted colleague from Chambers, Datta. We're going to be giving you a bit of a whistle-stop refresher, if I could call it that, certainly my part of it, over limitation and capacity and the role of experts. We are drawing inspiration from a case called Aderounmu and Colvin. Judgment was handed down this summer in August by Master Cook. It was a limitation-only trial. The reason that this case is instructive is because it has a very handy rundown of the law of limitation in it, and a nice roundup of case law associated with the primary statute, as well as looking at issues with capacity when limitation arises, and the instruction of experts around capacity as well. So I'm going to handle more of the limitation side. Anna's going to deal with more of the capacity side, and then I'll try and come in at the end with some practice points, and then there'll be time for questions, I'm sure, as well. Feel free to put them in the Q&A if you have them as we go along, and we can talk about them at the end. So what happens, the facts of this case I'll come to in a moment, but really what this case deals with in terms of limitation is he sets out, of course, what we hopefully all know, the primary limitation period for personal injuries from section 11.4 of the Limitation Act, being 3 years from the date on which the cause of action accrues or the date of knowledge, if later. And he sets out issues that follow on from there, 11.5. If the person dies, the period of limitation will, of course, extend. And then he also runs and looks at section 28 and section 38 of the Limitation Act, because these come into play when a person is disabled, and limitation may be extended in those circumstances. So section 28 means that if you are under a disability at the time that the cause of action accrues, limitation effectively stops, and you will be considered disabled for the purposes of the Limitation Act under section 38 of the Limitation Act, which refers back to the Mental Capacity Act. So if you lack capacity, you are also going to be considered disabled. So limitation would not run from the date of the accrual of the cause of action. That is the starting point in law where this limitation trial kicks off. The factual matrix is that on the 19th of November 2009, the claimant attended his GP. The judgment refers to the records, which say that he couldn't talk clearly, was extremely inarticulate, and it was hard to work out what was going on, and further tests were arranged. So then on the 23rd of November 2009, the claimant suffered a stroke and was left with serious neurological injury, including right hemiparesis and residual persisting dysphasia with regards to written and spoken language. That was November 2009. The claim was issued on the 10th of October 2017, just under 8 years from the date of the injury, so quite some time. And the particulars of claim asserted that he was a protected party. The defendant raised limitation in the defence. They denied he was a protected party, and they argued that he had capacity to conduct litigation at all material times, and that the cause of action accrued on the 23rd of November 2009. In the reply to the defence, the claimant reiterated that he lacked capacity and was under a disability, and that limitation never started to run. Or if he was found to have had capacity, he didn't have knowledge for the purposes of section 14 of the Limitation Act more than 3 years before the date of the issue of the claim. Or if he was found to have knowledge, then they sought disapplication of the primary limitation period under section 33 of the Limitation Act. Each party had evidence from a psychiatrist and a neuropsychologist. It was a hybrid hearing with CVP, and I think it ran over a number of days, and I think there was a break as well during the trial. The reason that this is a nice read, this case law, and reading cases isn't always fun, but this is quite a nice one to read, it's quite narrative, and also the breakdown by Master Cook is quite helpful. So I'm going to jump over the capacity point because Anne's going to cover that without wishing to give spoilers, and go straight to the did he have knowledge question, which is the secondary argument raised in the reply. They argued that he didn't have knowledge and he couldn't have brought his claim any sooner. Master Cook runs over section 14 and reminds us that it sets out that the date of knowledge is when the person believes that the injury in question was significant, and that the injury was attributable in whole or in part to the act or omission which constitute the negligence or breach of duty, and that they know the identity of the defendant. An injury is significant if the person whose date of knowledge is in question would reasonably have considered it sufficiently serious to justify instituting proceedings for damages against a defendant who did not dispute liability and was able to satisfy a judgment. Master Cook refers to the fact that the case law on the application of section 14 is quite overloaded with authority, and he draws and reminds us that section 14 should be capable of ready and sensible application with primary reference to the plain statutory language. Sorry, Anna, can you just wave if you can see me, because my computer's flagging up all sorts of things about Zoom. Great, thank you, I'll just carry on. Plain statutory language is where I'm at with the knowledge. He reminds us that generally knowledge for the purposes of section 11 requires a state of mind of sufficient certainty to justify the claimant embarking on the preliminary steps for making a claim for compensation. Is that knowledge objective knowledge, so clear objective facts which indicate knowledge, or is it the claimant's own subjective understanding as to whether or not they're in a position where they could bring a claim? He reviews that as well. The knowledge can be actual or constructive. Would a normal adult in the position and with the knowledge of the claimant have sought expert advice about the cause or attributability of his condition? In this case, what transpired, the defendant's arguments were that there were clear facts on the face of the medical records that demonstrated his knowledge. In this case, he had expressed to, I think it was speech and language therapists or occupational therapists, within a year or so of the index event, that he was disconcerted about the treatment that he'd received from his GP, and how he felt that maybe he hadn't had the kind of treatment that he should have had fast enough. And so in this case, there was objective evidence of his date of knowledge, and it was deemed to have been actual knowledge at that time. But presumably what the claimants were arguing is that when is it reasonable for a claimant to seek advice on any claim will depend on the situation in which they find themselves, and the consequences of the accident that they've suffered. And it isn't actually set out in the judgment, but reading between the lines, it seems that the claimant's position here was that the same issues which were affecting his capacity, and the same issues which were impacting quite seriously upon his functionality in the claim, were the same issues which were impacting upon his ability to understand that he was in a position where he could bring a claim. In any event, the judge did find that he had knowledge from 2010, December 2010. So the third fallback position of the claimant was to see if the court would disapply the primary limitation period under section 33. Again, Master Cook has really kindly, nicely set out here the law for section 33, and a review of the case law reminds us that when we're looking at section 33, what that means is the degree of prejudice which will be caused to the claimant, the length of the delay and the reasons for it, the cogency of evidence in light of the delay, the conduct of the defendant in responding, the duration of any disability, the extent to which the claimant acted promptly and reasonably once he had knowledge, and steps taken to obtain medical, legal or other expert knowledge. He also reviews the Chief Constable of Greater Manchester Police and Carroll case from 2017, which is itself, of course, a review of much of the case law on Section 33. He reminds us the primary burden is on the claimant to show the prejudice to them would outweigh that to the defendant, which is not necessarily going to be a heavy burden in most cases. However, it is fact specific in each case. Thereafter, there's an evidential burden on the defendant to show that the evidence adduced or likely to be adduced will be less cogent due to the delay. Prospects of a fair trial are important, and defendants are to be protected from the injustice of stale claims. And then finally, proportionality. Is there a thin prospect of success? Is the claim of modest financial value? This will also factor into the court's mind when making a decision on extending the limitation period. In this case, Master Cook found that the length of and the reasons for the delay given by the claimant were sufficient to extend the primary limitation period. And that is because all of the evidence, well, I say all of the evidence, some of the evidence really did add up to build a picture of a gentleman whose disabilities arising as a result of the stroke meant that he required a great deal of additional support to understand the issues arising and to understand the issues that were being presented to him in the claim, and to have additional time, for example, to consider every point that was being made. So he accepted that this was very relevant to the delay. He also accepted, interestingly, that the claimant had strong Christian principles, and he was recorded as being in the records in a very emotional state about the idea of making a claim against his general practitioner. And he finds that, in his view, there was a difference between making a complaint to the GP or a hospital about what had happened and taking legal advice with a view to bringing a civil claim. And then finally, he accepted that the reason the claimant had had the fortitude to bring a claim at all was because of all of the help that he'd required from his wider community to do so. He had a litigation friend, a Mr. Eden, who had encouraged him to bring the claim and to assist him in bringing the claim. Although Master Cook doesn't particularly form a favourable view of Mr. Eden overall, he appears to accept that the level of support that he required to bring the claim justified extending the primary limitation period in his case. He also accepted that the claimant was primarily preoccupied with conducting his immigration litigation until October 2017. When it came to looking at the evidential burden on the defendant and the cogency of the evidence, it was very clear that all of the medical records were there. They were clear. There wasn't an issue that any of that evidence deteriorated over time, and it had obviously been heavily relied upon by all the experts up until that point. Moreover, the defendant GP, although she didn't give evidence at the limitation trial, her witness statement indicated that she remembered the exact consultation with the claimant. So I think it might have been difficult for the defendant to argue that there was going to be an issue with cogency of evidence in light of that. So overall, it seems the authorities are stressing the importance of whether it's still possible to have a fair trial than on a punitive approach to delay. And I'm going to look at my other screen and say, Anna, it's over to you now to bring us onto the capacity and experts points.
Thank you, Gemma. So when Gemma and I decided we were going to do Law with Lunch on this, you might think that limitation and capacity seem fairly heavy going with regards to law. And you wouldn't be wrong on that. Apart from this particular case, I think is really, really helpful of setting out the law in both areas. And with regards to capacity, certainly, it's quite an interesting read because it sets out some of the common pitfalls that you would have in relation to capacity evidence, but also it shows how the way in which the solicitor dealt with the case then had a knock-on effect in relation to limitation as well. So hopefully we'll be focusing more on the evidence and less on the law, which will make this section of it interesting and not too heavy going, bearing in mind over law. That's not to suggest that Gemma has gone overly into the law, because I can see her laughing on my screen at the moment. So that's not meant to be a subtle dig at Gemma in any way. So dealing with a capacity, the starting point for any capacity claim is that capacity, there's a presumption that somebody has capacity, and that presumption has to be overturned in some way with the evidence. The second kind of fundamental for any capacity assessment is that capacity is decision specific. So it may seem counterintuitive, but a party could have capacity in one area of their life, but not necessarily in another area. So, for example, they could have a capacity to litigate if it was a relatively straightforward litigation. But if, for example, they got an overwhelming payout, they may not have capacity to deal with the finances. Likewise, you could have the opposite way, where the litigation is overly complex. They're going to have to be taking detailed instructions on behalf of from the client, and so they lack capacity to run proceedings. But then the damages may be modest, and therefore they could run deal with how they're going to deal with those damages themselves. So it's always worth bearing in mind when you are considering evidence, you're not looking at capacity in a general concept. You're looking at capacity specific to very individual decisions. Looking at this particular case, the evidence was first of all taken from Ms. Trask, who was the claimant solicitor, and Master Cook was particularly critical of the way in which Ms. Trask had dealt with this particular case. So she had first been contacted on the 12th of January 2017 by telephone, and by that stage it was 7 years post-injury. And she'd had a conversation with the client, and also from Mr. Eden, who was the litigation friend in proceedings. And limitation had been flagged up at the outset. And the conversation, her interpretation from that conversation was that the claimant didn't have capacity, and then that has essentially filtered down throughout all the evidence that she then obtained. So her starting point, and I would suggest it was a good starting point, was to start with getting a GP assessment with regards to the claimant's capacity. So she instructed Dr. Feltblower, and Dr. Feltblower stated in his report quite categorically that the claimant was able to understand the majority of my questions and discussions. He was able to communicate decisions and answers, albeit slowly and with difficulty. He was able to retain simple information for at least a few minutes. He understood why I was there, and his claim was against the hospital and his GP for having done wrong. So taking into consideration of all of that, what the GP, Dr. Feltblower, concluded was that the claimant did have capacity. And you can see, I would suggest that his assessment of capacity there was a fairly reasonable one. He's given the information to the client in a simple way. He's clearly assisted the client in retaining that information, because he's done, because he mentions the fact that the answers were given slowly and with difficulty, but he supported the claimant in providing that. And he states that the claimant was able to communicate those decisions when he was supported. He was able to retain that information and then come to a conclusion. So those are your fundamentals for capacity. In fact, he was able to take on board the information, process it, come to a decision, and then communicate that decision. Now, it's important to bear in mind that when one's assessing capacity, it doesn't necessarily have to be an overly complex procedure. The law is quite clear that on a relatively simple decision, the capacity assessment could be relatively straightforward and only last maybe 10 minutes or so. In fact, you provide the information, you assist the claimant with that information so that you give them a good chance at retaining it and supporting it, and then allow them to make a decision or certainly voice their decision back and that's how the process that you need to go through. So on the face of it, the first evidence that Ms. Trask obtained from Dr. Feltblower was that he had capacity. She obviously had some concerns with regards to that. So she then instructed Dr. Kerr-William, who was a neuropsychologist. And again, Dr. Kerr-William also did a capacity assessment and found that the claimant did have capacity to litigate. Interestingly, and what was flagged up by Master Cook is the manner in which Dr. Kerr-William expressed the decision. So the decision was, it says in the report, successfully passed the current mental capacity assessment. And that's an interesting choice of words, because as we've already discussed, capacity, there's a presumption that you have capacity. So it's not a test that you essentially pass. And the presumption, the starting point has to be that the claimant has capacity. You then assess the evidence, and that presumption has to be overturned. So the court was relatively critical of the fact that they successfully passed the current mental capacity assessment, because there shouldn't be a passing of a test, as it were. Ms. Tass said in relation to that evidence that she found the conclusion to be surprising and inconsistent with her experience of the claimant. And as a consequence, she obtained further capacity evidence, and one could perhaps suggest that she'd been somewhat expert shopping at this point, because she obtained a report from Dr. Dilly, who was also a neuropsychologist. Now, crucially in this case, when she initially instructed Dr. Dilly, she didn't provide him with the medical records. And what the judge said in this case is that whether that was a conscious decision to try and alter his evidence or not, it obviously was problematic, because those medical records were fundamental in assessing the capacity, whether the claimant did have capacity or not. As a consequence, the report from Dr. Dilly was somewhat contradictory. So at first, there was suggestion that he had capacity to make a financial decision, and then he changed his mind and said actually he didn't have capacity to make a financial decision. So as you can see, the claimant's evidence in relation to capacity was somewhat contradictory, and potentially, you know, if you were getting two out of three reports saying that the claimant has capacity, she should have had alarm bells ringing. But unfortunately she didn't, and she proceeded on the basis, therefore, once she got the answer that she wanted, was that the claimant didn't have capacity. The court also heard evidence from Mr. Eden, who was the litigation friend, and again the court was quite critical of Mr. Eden's evidence as well. Mr. Eden had known the claimant since 2008, and he was a friend from church. But what became clear into cross-examination was that whilst Mr. Eden may have a friendship with the claimant, he knew actually very little about the claimant's life. So he knew little about the claimant's wife or daughter, and crucially in this case, he knew very little about the fact that the claimant had undertaken a 3-week trip to Nigeria. So you can see the picture that was being painted even at this stage was that this is a claimant who is had more than able to deal with kind of everyday life situations, and therefore really raising red flags as to whether there was a capacity issues or not. The judge went as far to saying, somewhat damning, to say that felt that Mr. Eden was prepared to exaggerate the claimant's difficulties if it helped the claimant's case. And one of the things that the judge considered was the fact that Mr. Eden was there at the very first consultation with solicitors, and therefore was well aware of the impact of limitation and capacity and interplay between them. And the judge suggested that potentially that then altered his approach to the case with regards to the claimant's capacity. The judge also said that his evidence that he gave was rather contradictory from what was seen in the medical records, and therefore he treated his evidence with a high degree of caution. There was also expert evidence from Dr. Wright, who was the defendant's psychiatrist, and from the report, it's quite clear that a significant amount of weight was placed on Dr. Wright's evidence in preference to Dr. Dilly's evidence. And Dr. Wright was concerned about the level of disability that had been reported by the claimant, and that it was greater than what was recorded in the medical records. So what Dr. Wright did, which did assist the court, was that he went through the medical records and pulled out the relevant sections which suggested that the claimant had a good understanding of what was going on, and concluded that he clearly had was able to understand and communicate relatively complex information, and significant weight was put on by Dr. Wright was put on the fact that no professional dealing with the patient, bearing in mind that he'd suffered a stroke and the professionals were used to dealing with people who suffered stroke and therefore were alive to the fact that there could be capacity issues, had never raised any issue in relation to capacity. Looking at the types of things that had been flagged up by Dr. Wright, it was the fact that the claimant had challenged his immigration status. Not only had he challenged his immigration status, he'd actually appealed all the way up into the upper tier tribunal in relation to that. So as you can see, he was more than able to deal with litigation proceedings in that respect. And so I think that weighed heavily on the judge's mind. The medical records, no concern was ever raised with regards to his capacity, despite the fact that he had significant treatment between throughout the period of delay. So he, despite his stroke, he'd also suffered an aneurysm. He'd also had a diagnosis of sickle cell disease. He'd also dealt with the fact that he'd possibly contracted HIV and was able to get testing for that. In addition to that, he'd also had difficulty with housing and also student debt, and he'd managed to deal with statutory and voluntary organisations to address those issues. He'd also made the decision to marry in this period of time, and crucially, he'd also gone to Nigeria for 3 weeks and been able to manage, obviously, not only the travel there, but the travel during and planning of the holiday to Nigeria. But in the medical records, it was also demonstrated that he'd been able to plan in advance to be able to get a prescription for his daughter so that she could then take that with her to Nigeria for 3 weeks on the family holiday. So you can see, taking everything in the round, there was quite substantial evidence before the court with regards to the claimant's capacity. And I think what's important to note is that even though when the judge made his decision that the claimant did have capacity, not just at the moment in time when the court hearing was being held, but throughout the period, which was obviously crucial for limitation, the judge took into consideration not just the expert evidence that he had before him, but also the medical records and the witness statements, and kind of taking everything into account. So from the point of view of capacity evidence, looking at it for cases that we have, it's important to not only just consider the capacity evidence from professionals, but also take into consideration how that interplays with the medical records and also the witness evidence as well. And you can see from the way in which the solicitor approached this case, and that was criticised by Master Cook, that she'd started from the starting point that he'd suffered a stroke and therefore couldn't possibly have capacity. So she'd essentially dealt with it the wrong way round, because the starting point should be that the claimant has capacity, and to see whether the evidence essentially overturns that presumption. On a separate note from capacity, but helpful, I think, for general practice on a slightly different point, was Master Cook raised issues with regards to the joint reports that were before the court. And he called them overly lawyered documents, and in places that they descended into cross-examination. So in those joint reports, and there were 2 sets of joint reports, one of which the neuropsychologist, there were 41 questions, of which the court said were only 2 were of assistance. And what Master Cook relays, and it's in line with case law that's come out more recently in the last year or 2, was that joint reports shouldn't be proving grounds for parties of respective cases. They should essentially be short questions which are there to assist the court in narrowing the issues, rather than putting one side's case or another. And so that's something to consider when you are putting court cases, not just in capacity cases, but in any type of litigation. I'm going to pass over now to Gemma, because she's going to deal with the final aspects.
Hi, I'll try not to be quite as boring as I was before. I would just round off really by saying, if you believe that your client doesn't have capacity at the time that you receive your claim, it is hopefully the case that they will therefore be under a disability if they don't have capacity and you have evidence to that. So you'll fall under Section 28 and limitation doesn't run. But you must still confirm this with the defendant and obtain evidence and support, rather than perhaps hope that the capacity issue will just naturally fall in your favour. If your claimant loses capacity after the date of the accrual of the cause of action, then you must bear in mind that the clock has already started to run. It doesn't stop if you lose capacity for a related or unrelated reason. Limitation still applies. To stop the clock, you do need to rely on Section 33, and you do need to then still establish that they are under a disability and have lost capacity within the meaning of the Mental Capacity Act. If this is a point that's arisen in a sort of practice with clients, and if a claimant dies during the primary limitation period, the clock might restart from the point that they die for 3 years, or from the date of knowledge of their personal representative, whichever is later. So that is something else to think about, is what is the date of that knowledge at the point that they pass away. And the example that I've got here really is that if, for example, the husband passes away, but the wife knew that he died because his cancer was missed, then her date of knowledge is effectively the same time as the date of death. But if, for example, the son didn't know that his father had died due to missed cancer, he would only his date of knowledge would be from the date that he found out it had been missed, and that would start the clock again onwards. And really, that's the crux of what Anna and I were planning to talk to you about today. There are no questions in the Q&A. I'm sure that's because we ticked off anything that you might have had floating around your mind already. But if there is anything else, I'm sure Anna and I would be very happy to receive an email from you, or give you an opportunity to quickly type something if you'd like to. Thank you, Nicola, as well. Just thank you. Okay, well, thank you so much for coming today. We really appreciate it. And any questions? We're here for you. Thank you. Bye.